Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion in estate planning. Attorney Thomas D. Begley III is a certified elder law attorney with more than 35 years of experience helping families across New Jersey protect what they've worked for and planned for life's most important transitions. I'm Shamika Rhymes, and today we're talking about what happens when someone passes away without a will and how New Jersey law decides who gets what. Welcome, Tom.
Thanks. Great to be here.
Great to see you. Well, Tom, what does it actually mean legally to die without a will in New Jersey?
It means you're subject to what's called the laws of intestate succession. And just the ugly, feel that word should probably scare people off of dying that way. But basically, when you die without a will, the state basically decides where your assets are going to be distributed. I've done this for almost 36 years now, and I've never had anyone come to my office and say, you know what, I have a great idea. I want to do a will the way that somebody would have the state divide my money. So it's just something you want to avoid at, generally all costs. It used to be even crazier than it is now. But there are usually, two issues that come up when someone dies intestate. The first is how are the assets going to be distributed? And the second is who's going to administer the estate? And a lot of times that can create unnecessary complications and costly complications.
Well, how does New Jersey law determine who inherits when there's no will in place?
Okay, so there's what's called the Statute of Intestate Administration. If anybody wants to go on up what I call the nerd alert and Google this, it's NJSC 3B:5-1 at 6. So that's the section where the intestacy laws. Now, actually, part of it's made a bit more normal. If there's a situation which is a traditional family, I guess, and they're fewer and far between, but there's still a lot of them out there where it's a husband and wife, and there are the children between the husband and wife are all from the one marriage, then if one spouse dies, it goes to the other outright, which is pretty much what most people would want to do in their will. And then the other thing is that if somebody is single and has children, that everything would go, completely to those children equally. But that's about as normal as it gets, because, the first situation is not so dreadful if it's a surviving spouse. However, if there's debts, the surviving spouse, prior to taking on the ability to administer the estate, may have to post what's called a surety bond, which is basically an insurance policy to make sure that the debts get paid. And certainly when we create wills, we always waive the requirement of the surety bond. So you kind of basically, if you're the survivor, you've got to pay money to get your own money. When you have children, it's even more complex because let's say dad dies, mom passed on before him, and there's 4 kids. Well, all 4 have an equal right to serve as what is known as the administrator. That's the functional equivalent of the executor when there is no will. And either all 4 can serve together, which isn't going to happen, or they're going to pick 1 or 2 to act, typically 1. So if they all agree, let's say 3 of them say the 4th one's going to do it, the first 3 have to sign forms called renunciations, which says, I don't want to do it, but I'm okay with the sibling doing it. Well, if that happens, the good news is you can get somebody appointed. However, once again, because there's no waiver provision for a bond like you would have in a will, the individual actually has to post a surety bond to make sure that not just any debts, but really more importantly, the value of the estate is covered. So let's say, mom or dad passes and they've got an estate worth, $800,000. Well, the person has to go out and before they get appointed and have any authority to do anything, they've got to go to an insurance company. And there's not everyone does. It's kind of a specialized company, and they'll get what's called a surety bond. But they have to, they have to pay a couple grand maybe sometimes to get that bond. And that's an expense that you would kind of want to avoid. And then it's, and then if it takes more than a year to administer the estate, you've got to renew the bond. The big thing that happens more often these days, because families are becoming a bit more dysfunctional, is that the 4 kids can't agree on who's going to serve as the administrator. And if that happens, nothing is going to occur until there's a court order. And then what happens is somebody's going to step up and they'll file a complaint with the with local surrogates court, who in turn passes it along to the superior court, who handles the division that handles probate, and they'll ask to be appointed as the administrator. At that point, the reason they're going to say they're going to do it as opposed to anybody else usually becomes a lot of mudslinging. And then, of course, nobody takes that stuff lying around and say, and next thing you know, there's a lot of discord. There are sometimes it's not just because there's discord. You have families nowadays where somebody just, either A, disappears and no one's heard from them, or they've become estranged and you may know where they are, but they're just not going to sign anything to help the process move along. So really not sure. I mean, and these are the simple intestate cases. Once we start talking about blended families, it's even crazier.
I can imagine. Well, how do the rules change depending on whether someone is married, single, or has children from different relationships, since you mentioned blended families?
Well, this actually highlights what happens when you have a blended family, and it not only impacts blended families when somebody dies without a will, but it even can impact with a will. So let's talk about the first scenario. So the first scenario is, mom and dad, mom dies, dad after a couple of years of mourning, unfortunately now in this stage age, more like a few months of mourning, reconnects with somebody and decides that they want to get married again. What occurs is that if he dies without a will, basically the law says that wife number two gets the first 25% of the estate, no matter what it is, and 25% can't be less than $50,000, although it can't be more than $200,000. And then they split the rest 50-50. Now, I've never met anybody that's ever come into my office and said that was a great idea. And also, especially when marriages come about later in life, then what occurs is you're basically shorting your own children. I mean, the idea is to get married, you want to make sure your husband or wife is taken care of. On the other hand, you're certainly not making sure they get the lion's share of the estate. Now, the other thing that people need to be aware is that, as I said before, this doesn't just affect occasions where there's a husband and a wife and kids from a prior marriage and, somebody dies without the will. This will happen when somebody does have a will and the will was done prior to the marriage. So I'll give you a case where it happened. Basically, the law says that if you die with a will, but you got married after the will was executed, absent a prenuptial agreement, which could void this, but absent a prenuptial, which usually what happens, people don't get around to those, that the surviving spouse can take the share that he or she would have received if there had been no will at all. So a really tragic case happened years back. There was a guy that had been married for, 45 years to his wife. She passed away, and he decided that he was going to get remarried. And it was really a pretty awful case. I represented the kids. This guy who was seen as a pillar of the community actually had been carrying on behind his wife's back for many years. So that was, bad enough. But then he decides to marry her. I guess since she was the silent mistress for a number of years, that she would turn around and he should take care of her. So what he did was he took several $100,000, basically about $400,000 of liquid assets, and put her name down as a joint holder or beneficiary. And the only other asset he had, what was an important one, was basically this condominium he had down in Gloucester County, and a little bit of liquid assets. And the important thing was he lived in that condominium all his life, in the last 40 years, with an adult child who had disabilities. And although the adult child was mentally competent, he was impaired a bit cognitively, and he had physical limitations. However, that condominium that the father and the son had lived in for so many years, that was so important to the family that child continued to be able to live in that house for the rest of his life. And as a matter of fact, what dad had done in his will, and the other kids were okay with, was he said, look, I want this particular son to, have the ability to live here for the rest of his life. And then when he passes away, then whatever gets sold can be divided among the surviving kids. So what unfortunately happened was that truly in this case, wicked stepmother, when this guy died, she certainly took the $400,000 with a smile on her face. And then in the next breath, she filed an action in the probate court to get what's called the omitted spouse share. And so what happened, this guy's condo, which was worth about $400,000 to take care of his son with the disabilities, who likely wouldn't have had anywhere else to go, it wound up getting sold. And she got 50,000, first 50, she got the first $100,000 because that's 25% of 400. And then she got half of the rest. So she got 300,000 on top of the 400,000 that she already got. And the child with disabilities got $100,000. And, Dad had, in good faith, thought from everybody's, opinion that he had actually said to everybody, look, I have a will to take care of my son, and I have the assets outside of probate that are going to, take care of wife number two. And obviously his assumption of the law was disastrous.
Mhm. Yeah. Wow. Goodness. Um, I'm at a loss for words because I had no idea that that would play out like that. I wasn't sure where the story was going.
Well, I mean, but it does play out like that when people, don't plan. I have a matter that happened, wasn't a seedy, but basically a couple of years ago, there was a situation where, well, I've got a better one. Um, a, a gentleman I'd known for many years, his parents had gotten divorced, but for whatever reason, I guess he was the common thread that everybody liked. Mom and dad that had two children. Their son, who was a single guy, stand-up guy, very, good person, and a daughter who has a bit of handful, bit of challenges. And the son and the daughter, I mean, there was a acrimony, but they just really they led separate lives. They didn't care much for each other. So it wasn't the most awful thing that could occur. But what happened, this guy, in the course of his single life, had gotten about $3.5 million of an estate. And because he lived outside of really where I was, and just because of certain things going on with my schedule, I couldn't take care of the will preparation. So there was a really good attorney. She prepared a great will. And the one thing he was sure that he wanted was a couple of really good friends, this younger couple that he'd known for years that he just really connected with. They did a lot of stuff with him and for him. He wanted them to get the lion's share of the estate. That he wanted a couple other, charities in there, a couple other people. And he literally fiddled around with the will for about a year. The problem was, and because he fiddled around and never came to a final solution, he passed away without ever signing it. And the $3.5 million that everybody knew that he wanted most of us to go to one particular couple and to other folks, all $3.5 million went to his sister, who he didn't really care for. So, and I had another case similarly where there was a couple, they didn't have any kids. He wanted to leave everything behind to a couple of his brothers and a couple of his cousins because he was going to file for a divorce. However, he did not act with speed in either case. He died without a will. The will was sitting around for a few months waiting to be executed. And he was just, tinkering around with it. And then the other was never got around to filing for the divorce. So he dropped dead. And this guy had $8 million. And that wound up going to someone. And literally, I mean, we're talking separated for 5 years. And I understood that she did play the role of the grieving widow at the funeral. So even though she was able to cry the river for him. And just, it was awful. And one thing I've always told people, when you have conflict going on in your life, you can always change your will, so it's better to have an imperfect will that you can change later than no will at all.
Well, if there is no will, then who is responsible for stepping in to handle the estate?
Okay, well, there's a pecking order, as I'd indicated before. So if it's a surviving spouse, and also this, despite all the various, distribution patterns. So if someone's married, the surviving spouse comes first. And then after that, it would be the children. It's just, then if they're, no spouse, no kids, parents, then not the siblings. So there's a pecking order. But the problem that you have really with those pecking orders is threefold. The risk is A, they can't agree, so we got to go to court. B, they do agree, but the person who gets appointed has to post an insurance, a bond to make, which costs some money. And the third thing is you have people where you have fractured families where sometimes you can't find someone or somebody's just non-responsive. And if you can't get that, piece of paper you need to renounce from that, long distant, sibling or other child, you're going to have to go to court to get an order. And if you want to go into court, especially when there's a family function, a dysfunction, what happens is the judge can make an evaluation and say, all right, I understand why, nobody wants this particular person to serve. And so I'll, go with the majority and appoint this individual. But there are a number of jurisdictions, there are judges that feel, look, if there's family discord, they're going to appoint somebody independent. So they'll appoint an attorney to do that. And I'm not taking any cracks at my profession. However, people that, we're not getting around to doing well, a lot of times they didn't like lawyers like paying legal fees. It's kind of a twisted irony that upon their death, a chunk of their estate might be used to pay for an attorney to handle the distribution of the estate.
This has been super informative, and I really appreciate the real cases for examples so that we understand like what can happen. So thank you for that, Tom.
My pleasure. I think those are important because I think when you hear about things that actually happen, and well, these scenarios, they're not far-fetched. In this day and age, it should be something to encourage someone to get their estate planning in order. So, really the takeaway should be, if you haven't done it, do it. And just remember, if you're not 100% sure what you want, something, is better. Something that you can change later is always better than nothing at all.
Absolutely. Well, that is it for today's episode of the Estate Blueprint, Planning Your Future with Tom Begley. If you'd like to learn more about how Tom Begley and his team can help you create a plan that reflects your wishes and protects your family, visit Begley3law.com. Thanks for listening, and don't forget to subscribe, share, and leave a review so more New Jersey families can find the guidance they need. Thank you, Tom.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.